All right, why don't we get going? Good afternoon to everybody. We're so delighted that you could join us this afternoon to discuss a topic that I find really interesting, and I know my colleague Katie Dalton does as well, international Hague child abduction cases. This is an area of expertise that Katie and I have focused our practice on, and we've handled a ton of cases. And so we're really excited to share our expertise and practice tips with you and be able to have what we hope will be a really enjoyable discussion this afternoon, and certainly answer questions at the end. So before we get into the substance of today's webinar, I'd like to just briefly introduce myself to those of you that may not know me. I'm Elizabeth Crowley. I'm a partner at Burns & Levinson in the Divorce and Family Law Department. I have been at Burns & Levinson since March of 2016, so just over 15 years, and I specialize exclusively in divorce and family law, as well as part of that, international Hague child abduction cases. And so with that brief introduction, I'll pass it over to my colleague, Katie Dalton, to do the same. Thank you.
Hi, everybody. Good afternoon. So good to be here with you. I have been an attorney at Burns & Levinson in the private client group now for about 4 years, and I've been practicing in all areas of domestic relations law, all aspects of litigation from start to trial, for over 12 years in the family law venue, both inside of Boston and outside. I'm active in several of the local bar associations, and I'm also on the board of trustees for the Greater Boston Stage Company. And one of the great things that I've got to do since being at Burns & Levinson is a Hague Convention case with Elizabeth, and it really allowed us to get a sense of how these cases work and some of the things that we need to be cautious about. So I'm going to turn this over to Elizabeth to talk about getting a Hague Convention case started, the initial steps, and how to prove a prima facie case.
Absolutely. Thank you so much, Katie. And so, as far as Hague international child abduction cases, what are they? I'll tell you what they're not. They're not a child custody dispute where the federal court here in Massachusetts or any federal jurisdiction in the United States is charged with determining who's a better parent or what is in the best interest of a child. And that's a really important factor, whether you are pursuing on behalf of a petitioner a Hague Convention case, or whether you might be in a position of defending a parent who's been accused of wrongfully removing or retaining a child. And so under the Hague Convention, which went into effect in 1980, we have the Hague International Child Abduction Treaty. Okay, and we also have here in the United States something called ICRA. The acronym is ICRA, and what that is the federal counterpart here, the federal law here in the United States that implements the Hague Convention as it relates to international child abductions. Obviously, before we even get out of the gates, one of the first lines of inquiry is whether or not the other country or jurisdiction that you may be dealing with is a signatory to the Hague Convention. They need to be in order to have a cause of action under the Hague Convention, in order to be able to seek the return of a child who has been wrongfully removed or retained. And so that's really important. And a few tips, before, whether you're a practitioner, whether you're a party that might unfortunately be involved in one of these exceedingly challenging international jurisdictional battles. One of the first things to make sure you do right at the beginning is to do your homework. And what do I mean by that? It's really important before you file a Hague application seeking the return of a child who you have alleged has been wrongfully removed or retained, that you make sure, A, that you have a cause of action, B, that you can locate the child and the parent who is accused of having kidnapped or wrongfully removed or retained a child. And we'll get to some practice tips later on how you can go about doing that. Needless to say, when people have engaged in self-help and bad behavior, they are not often flagging where they are for the parent who has been unfortunately left behind. And there's certain tools, private investigators, and other types of tools that we can implement in order to hopefully be able to locate the child as well as the parent, because that's obviously important for these proceedings. So after you've done your homework and figured out, hopefully, where the other parent is, where the child is, you want to be asking, if it's your client or if it's yourself or it's another individual, you want to be asking some key questions in order to be able to prove what we call our prima facie case under the Hague Convention. The first is, what was the habitual residence of the child prior to the wrongful removal? And prior to the wrongful removal is really important, because sometimes when individuals have engaged in self-help and removed a child, they say the new location is the child's habitual residence because maybe they wanted to go there for a long time, or maybe the parent has ties there. And that's not the proper inquiry. The proper inquiry is immediately prior to the wrongful removal or retention. What was that child's habitual residence? That's the first item that you want to be certainly able to prove as part of your prima facie case. And then the second is, did the petitioner, the party moving forward, have custodial rights to that child? It can't, unless there's a custodial order, it can't be an aunt or a friend or somebody that just wants that child to be returned. It actually has to be a parent, an individual, a party that actually has custodial rights in that jurisdiction. And that can take different forms, whether it is pursuant to a divorce decree there, whether it's pursuant to a custody order there, whether it's pursuant to a paternity decree or order there in the foreign jurisdiction, or simply you might be a married couple or even a couple that's not married that under the laws of that country is exercising and has rights to exercise custody over that child. And finally, was the parent who is seeking relief actually exercising their custodial rights? So you want to watch out if an individual has abandoned a child, so to speak, or has not been exercising their rights in order to see their child. That can be a problem. And I would just suggest, before I pass it off to Katie, in order to go over the 6 narrowly construed affirmative defenses, you want to really do your homework right up front and make sure that you have a strong case, and make certain that you're able to meet that 3-pronged analysis as part of your prima facie case. Katie?
Thank you. One of the things I will note in a case like this, instead of the terms plaintiff and defendant, you'll hear petitioner and respondent. And the petitioner is the person who is applying for relief, seeking for the child to be returned. And the respondent is the parent who has taken the child and is asking, potentially raising some of these defenses in response to a complaint being filed, a petition being filed. And so the respondent has an opportunity to present certain defenses to the court in order to prevent the child being returned to the habitual residence. A couple of things to note about the defenses. First of all of the defenses are to be narrowly construed. And so the respondent does have a higher burden of proof in terms of showing to the court what is necessary to be successful on any of these. And the other thing to note is that the court maintains the ultimate discretion. And so that means that even if a respondent is successful on proving, for example, that the petitioner was not exercising custody rights at the time of the removal, it does not mean necessarily that the child is not returned, The court still has that discretion to return the child regardless of the respondent's success in proving these defenses. As Elizabeth mentioned, there are 6 different defenses. The first one we both mentioned a couple of times, and that is if the petitioner was not exercising custody rights at the time of the removal or retention. That could be something that the court takes into consideration as a reason why, it may not be appropriate for the child to be returned. An important thing to remember about this defense is that it doesn't necessarily mean a petitioner has to have some type of formal custody agreement. It could be as simple as the petitioner was going to see the child in the morning and walking the child to school every day. It could be as formal as having certain custody rights provided by a court in another country. The second affirmative defense is consent or acquiescence to the move. And that is a situation in which the petitioner may have said at some point to the respondent, I'm comfortable with you taking our child to this country, or I'm in agreement for you to do that. And if the respondent has that proof or documentary evidence to show to the court, hey, listen, the petitioner already agreed to this, that's something that the court would then take into consideration. And that one thing to note about that defense is that it could be tied into any type of delay in asserting your rights as a petitioner. That could be, if the petitioner has taken too long to try to get the child back or assert certain custody rights, that delay could be held against the petitioner. The third affirmative defense is a child who objects to the return to the habitual residence. One thing to note about this is a really case-by-case specific defense. The child's age and the child's maturity are really the 2 most important factors that go into determining whether or not this child's objection should be something that's considered by the court. I think we're talking about if a child who maybe is 4 says, well, I really like living with mom, I don't want to go back and live with dad, may not be something the court takes into consideration. But if you have a 13-year-old or 14-year-old who is very mature, can articulate why he or she doesn't want to go back, that is something the court may take into consideration as a defense. The fourth, and I see as the most common defense, is the well-settled defense. This defense is very fact specific. Case by case determination is made. And there are 2 prongs that must be met in order to prove a well-settled defense. The first being that the proceedings, the Hague Convention proceedings and the federal court filing was done more than a year after the wrongful removal or retention. And then the second factor, the second prong, is the child is now well settled in his or her environment. And again, that second prong, whether the child is well settled, is also a factual based analysis. And the court is going to look at all relevant factors when it comes to this defense. And some of those things include the child's age, stability and duration of a residence, if they have come to this country, stayed in the same home for several years, they are part of the community, what the stability of the child is in school or daycare if the child's not old enough to be school age, has the child consistently been going to school, are they, a member of the school community, are they involved in different things through that. Another factor that the court can consider are friends and relatives that are local to where the child is now living. So, for example, if the child is living in Boston, Massachusetts, are there friends of the child that are here? Are there relatives of the child that are here? Are there friends that the child has made since living here? And I think I mentioned before, the community. Is the child involved in extracurricular activities? Does the child do volunteer work in the school or the local churches or areas? And then the court also considers the respondent's situation. What's the respondent's work history like? Has there been a stable employment? Has there been income available to support the child if they were to stay here? What's the financial stability of the home at this point? And then lastly, and one that Elizabeth and I encountered personally in a case, is what's the status of the respondent's immigration? Is there an immediate concrete threat of deportation that could create a situation that is not stable for the child? If a parent is deported, sometimes there is a question of whether the child goes with that parent, and then what happens? And so immigration status, despite the fact that I think a lot of immigration status is time consuming. It takes a long time. And so I think it's difficult for a petitioner to say there is some immediate concrete threat, when the respondent's next immigration hearing is not for 6 years. So those are all things that the court will take into consideration, and really anything else, any other factors that may be relevant or important to this well-settled defense. Is that child well-settled in the community? The fifth affirmative defense is the grave risk of physical or psychological harm if the child is returned. Did the child come from an abusive situation? Are there things going on in the country where the child would be returned to that could potentially put the child at risk? And then the sixth defense, affirmative defense, which is very, very infrequently used. It actually has never been successfully argued in the United States, and there are only very limited examples in other countries, but that talks about the protection of human rights and fundamental freedoms. And that a lot of times goes to political issues in the country. Would this create a situation that has ripple effects, so to speak, in the community where the child was removed from? And the other important thing to remember about all of these affirmative defenses is that the petitioner certainly has the opportunity to present facts and evidence to show that these affirmative defenses should not be applied in this situation. So if, for example, a respondent is saying, my child's well settled here, she should remain here, the respondent has the opportunity to do things like request discovery from the school to show the child hasn't been consistently attending, or request documentation from the respondent's employer to show that there has not been a long period of consistent employment. So it is not as though the respondent presents these affirmative defenses without some response. The petitioner does have the opportunity to do that. And discovery in this type of a case is really important. It's one of the most important things you're going to do to get evidence not only to support your prima facie case, but also to respond to any of these affirmative defenses that the respondent may raise. So at this point, I'm going to pass it over to Elizabeth, who's going to give us a little bit of a case highlight and talk about the application of this in real life.
Absolutely. Thank you so much, Katie. That was a great overview of the 6 to be narrowly construed affirmative defenses. And before I get into the Goldman case, which was one of the earliest high-profile Hague International child abduction cases, just a few comments with respect to affirmative defenses strategy and whether you end up being a party to litigation or whether as a practitioner you are representing an individual. Just assume that affirmative defenses are going to be raised. That should go without question, and be ready to deal with them. Katie mentioned that, how critically important discovery is. Do your discovery with that in mind. Obviously, you want to be able to prove your prima facie case. You need to. But then with respect to the affirmative defenses, assume they're going to be raised, at least the primary ones that tend to be raised. Gear your discovery towards that, and make sure very early on in your pleadings, in your presentations, in oral arguments in federal court, that you're getting ahead of those. I think that's really, really important. And keep in mind as well, and the federal court bar certainly knows this, but it never hurts to just lay out the evidentiary burdens, the prima facie case, because some federal court judges have had more experience than others with respect to these cases. These are not cases that they tend to see every day. My experience has been the federal court bar has been extremely diligent, thoughtful, and engaged on these cases, which I've really appreciated as a practitioner. They take their role and their obligation very seriously. And, you know, keep in mind, affirmative defenses, obviously the burden is on the party raising those to be able to meet their burden. But the court, the federal court, still has the authority to obviously hear the evidence and to order a return, even if affirmative defenses have been raised, whether it be the well-settled defense, whether it be grave danger, and determine not only obviously the credibility of the evidence presented, but whether or not they've met their burden anyway, and notwithstanding whether or not the child should be returned. And so, you know, with respect to, and one more thing before I get to our case overview, for anybody that is looking for additional resources with respect to affirmative defenses, with respect to the you know, case-specific analysis that the federal court engages in, take a look on the State Department's website. One of the best resources out there. I'm on the State Department's, call it a short list of experts that handle international child abduction cases, and they refer me cases when parties are looking for expertise in that area and representation in these difficult cases. There is a host of information and resources on there, but there's a very helpful and lengthy manual, and you can get a PDF of it on that website, that provides just such excellent analysis. And so if you have a tricky case, don't recreate the wheel right away. Take a look there, see how the affirmative defenses have weighed, see what body of case law might be there to support you, and use that obviously within the presentation of your case and strategy. And so with that being said, I'll get into the David Goldman case. And so needless to say, you know, the media has seen, you know, many cases, both celebrities and non-celebrities alike over the years, that have been parties to this excruciatingly, you know, challenging type of situation with respect to the custody, care, and well-being of a child with international borders put in between. I can think, as a mother and practitioner alike, I can think of nothing worse than to be in a situation like that and not know what to do. Very, very complicated area, and without the proper resources and professionals guiding you, it is complicated. It is complicated even for practitioners. And so David Goldman was one of the earliest well-publicized, high-profile cases where there was an international child abduction. Back in 1999, David Goldman, who's from New Jersey, had married Bruna Bianchi, who was a native of Brazil. They had a little boy, Sean, and lived in New Jersey. All seemed well until it wasn't. Mother had gone to Brazil ostensibly on a 2-week vacation with 4-year-old Sean. The father, David, was going to meet them in Brazil with mother's extended family and enjoy a nice vacation with their son, who, as I mentioned, was 4 at the time, and received a call from his then wife and the mother of the child that she wanted a divorce. She wasn't in love with him anymore, wanted sole custody of Sean, and wasn't returning. And so needless to say, you know, David Goldman was beside himself and really feeling helpless, I have no doubt, with respect to what to do. Beyond the obvious barriers being distance, you know, a country where you may not, you know, speak their native language, and a party that is resisting returning a child, there's obvious cost and legal proceedings that have to be engaged in order to be able to seek relief. The good thing in the David Goldman case, after extensive litigation and cost and resources and intervention, his son in 2009, at the end of December, was returned to his care and custody, and they flew home. and have been in the United States since. The mother in that case actually died in childbirth. And you would have thought at that point, tragic as that was, that would have ended the litigation in Brazil and the attempts to keep Sean there over his father's objection. It didn't. Mother had actually remarried down there after she procured a divorce down in Brazil to a high-powered divorce attorney down there in Brazil, Sean's stepfather subsequently. And so he continued to fight for custody, as did his grandmother. And it was a very, very challenging set of facts for the father going up against a powerful family down there in the Brazilian court system. It went all the way up to the top of the Brazilian court system. There was some political pressure on the United States side, both by then President Obama and then Secretary of State Hillary Clinton, that got involved, as well as his local representatives, to be able, to do some really skilled diplomacy and negotiation with respect, to the Brazilian counterparts. And thankfully, the highest court in Brazil ultimately did the right thing. And, again, I go back to what I said at the beginning. What are these cases? Are they who's a better parent? Are they what is Brazil better? Is the United States better? They're not. This is, as a jurisdictional matter, where should these disputes be had? Has a child been wrongfully removed from one jurisdiction to another? If so, the presumption, the strong presumption, I should say, under the Hague Convention is that child should be returned. It dissuades engaging in self-help. It dissuades a party from engaging in forum shopping. In the Goldman case, clearly mother engaged in self-help. She was deceitful. She planned to go not for vacation to Brazil, but to stay there. And once she got there, she engaged in self-help, and she used the resources at her disposal on the Brazilian side to insulate the self-help that she had engaged in, and to prevent father from having access, meaningful access at least, to their child. And so, the signatories to the Hague Convention, and again, more countries continue to join, is really to protect both jurisdictions, both from children being wrongfully removed, whether it's Brazil, whether it's Portugal, from that jurisdiction to here, and obviously the reverse of that. The State Department is very used to working with the central authorities in the counterparts that they are dealing with. There's translation services. And they really do, they're there as resources and to support, because of, being signatory to the Hague Convention, efforts for children who have been wrongfully removed and retained to be returned. In the Goldman case, obviously a lot of expense, a lot of lost time, and the Brazilian court system initially was resistant to that child being returned, notwithstanding father's prompt filing of a Hague Convention petition, which is the first step that a parent must file. You want to do that within 1 year. That 1 year mark is really critically important, both with respect to the survivability of affirmative defenses that can be raised, but also to just not allow the passage of time to work against you. When this, if a situation like this happens and you're representing a client, you want to have your client file a Hague petition ASAP. In the Goldman case, he filed one within approximately 50 days. He didn't wait. He didn't hope that things might get better. He knew he was in trouble. He filed that Hague petition, and the litigation went off from there. One of the questions that does come up sometimes in these cases is, I've filed my Hague petition within a year. Do I have to file my litigation, whether in a foreign jurisdiction or typically when I'm involved here representing the party seeking the return of a child within 1 year? The sooner you can do it, the better. But needless to say, if you have been doing absolutely everything in order to advance your case, find your child, protect your rights, you've filed within a year the Hague petition, and you've taken other steps, whether it be to locate a child, whether it be to try to work for the return of that child through the local police or otherwise, you know, again, sooner rather than later to file your action in federal court. But I have found, you know, just as a practice tip, that the federal court, if you file the actual complaint in federal court and it's a little bit after a year, I haven't found that to be a problem where a party is zealously pursuing their rights to relief. What the federal court, I have found, does not do is punish a parent who is dealing with a party that has absconded, sometimes hidden themselves in the community, and done everything they can to not be found. I've found that the federal court is not going to be unreasonable or punish a parent who has been harmed in that regard. And so thankfully, to round out on the Goldman case, you know, really good result, obviously, for father and son after several years of you know, real tragedy. And they live here in the United States, last that I checked, and you know, have a close bond now, which is a great thing. And so with that being said, Katie, I'll pass it back to you for another case study and some interesting analysis.
Thank you. I just wanted to touch before I jump in the case on a couple of things that Elizabeth had said and resources that are available. Elizabeth had mentioned going to the State Department website. They have a great tutorial, as she mentioned, that goes through the case, the defenses, and a lot of different samples of what can be provided and presented to the court. The other thing that's accessible is all of the Hague Convention cases. So if you do a Google search for the Hague Convention cases or recent Hague Convention cases, it breaks it down not only by the year that the case was issued, but also in terms of what the holding was regarding whether it was to define habitual residence or perhaps address one of these affirmative defenses that I've talked about. I find that going to those cases is a really great resource. And oftentimes, if this is your first case or if you're looking for additional resources, feedback from other practitioners who've done this before, you can often find the attorneys that have the names of the attorneys and the firms that the attorneys come from who have worked on some of these recent cases and may have some experience, particularly if you have a nuanced issue or a fact-specific issue that may have been dealt with in a case before. The other thing that I wanted to note is that for certain practitioners, doing a case in federal court, like something through the Hague Convention, is different than our everyday practice. For us, for myself, primarily, I find myself in probate and family court. I know other practitioners are maybe more frequently in district court, but it is important to remember that it's a different venue. Federal court have their own rules, their own guidelines in terms of formatting of motions, length of time for discovery. And so it is important to take a look at what those rules are and be familiar with the differences that may be there, different than what your everyday practice is, because these are they're very fun cases to work on. They're very time intense, a lot of time required during discovery, preparing your pleadings, presenting the information to the judge. And you also need to remember that your judge may not have a lot of experience with these types of cases. In federal court, this is not a common case. The last case Elizabeth and I worked on, our judge thankfully had a very small amount, but some experience with dealing with these cases. But he had been on the bench for many years, and so that was a result of that. But it is important to also educate the judges in your pleadings and what is required to prove this case and what the court needs to find. I know in our case, there were specific issues about immigration that the judge wanted to be briefed on. He wanted to know, what impact should this have? How much weight should I be giving this issue? And so you need to be prepared to educate your judge on some of those things. And so another case that was pretty well known in the public and in the tabloids was that of Kelly Rutherford and Danielle Gersh. And Kelly Rutherford is an actress. She's known for things like being in Melrose Place and Gossip Girl. And she and Danielle have two children together. They have a son and a daughter who are elementary school kids, young children. And in 2012, they began litigation regarding custody. And Daniel was here in the United States on a work visa from Monaco, where he lived. And in 2012, during their litigation, his work visa expired. And despite taking great efforts to try to renew it and remain in the United States so that, the parents of these children would not be, continents apart, that unfortunately was not successful. And so the court in California made a determination through litigation that it was going to be in the children's best interest to go to Monaco with their father and live there, and for him to have custody of the children, at least while he was trying to get this work visa situation figured out. Mom, Kelly, was permitted parenting time with the children. She was allowed to visit with the children. And in fact, during the litigation, she was permitted to have the children in the United States for several weeks during the summer. And it was unfortunately at the end of that vacation where things went awry, and Kelly made a decision that likely had ripple effects and will continue to have ripple effects in terms of her rights with the children. She chose to withhold the children, not return them to Monaco, not return them to the custody of their father, despite a court order. She tried to play a little bit of a game with the courts in terms of vying for jurisdiction in places that she thought she may be successful. In fact, she had a court issue a temporary custody order for her to keep the children, only to then be overturned to find out that the jurisdiction wasn't proper. And so ultimately, a judge ordered her to put the kids on the plane and be returned to their father. And that's where they continue to live today. And many commentators, legal commentators, people who have experience with the law in Monaco, comment that things could have gone a lot worse for her by making that choice, by withholding the child from their father who had legal custody of them. And I think this is the most important thing to remember in these types of cases: is a judge is tasked with making sure that the court that has jurisdiction or should have jurisdiction is the one making decisions about the custody of the children. And to deny either the petitioner or respondent those rights would just not be appropriate. And so it is important to remember, like Elizabeth has mentioned, this is about where jurisdiction lies and where the custody dispute should be heard. This isn't the custody dispute per se. And so that is a little bit of a glimpse into how this plays out in everyday life. Like we've mentioned, we have experience with these types of cases. They are very fun, very fact specific. You can be very creative in terms of the resources you utilize, where you look to for information, where the respondent is living, what are the resources you can access that she or he may be involved in, whether it's church programs or community service or even just where they're employed. Don't be afraid to be creative and do things that you might not otherwise do when things are so clear cut. Thank you, Elizabeth. Anything else to add before we conclude here? I notice we have about 5 minutes left.
Absolutely. And I know we want to get to a few questions as well, any that were submitted before and any that any of the participants may have. So just a few practice tips, I'll call them. One, and I can't emphasize this enough, vigorously pursue relief on behalf of your clients. Time is not on the side of the parent that is seeking relief for a child that's been wrongfully removed and retained. Typically, at least the cases that I see, there is counsel for the parent that is here having been accused of wrongfully removing or retaining a child. Typically, in my cases that I've seen on a pro bono basis, there's no right or entitlement in these civil actions in federal court to counsel. But needless to say, the repercussions of losing are grave. And so typically, whether it's through Harvard Legal Aid or other types of legal services, or just firms taking on a case on a pro bono basis, you will see that counsel's involved, which is good because at least it gives structure to a case, both with respect to discovery, scheduling, but certainly, vigorously pursue your relief. If the case needs to be tried, almost all of them do. Very, very rarely are you going to have a settlement unless a party dismisses their petition or decides not to pursue, or unless a parent says, I know I did the wrong thing, I'll go back. You're going to have a trial. And so get the discovery that you need to get done. Engage in the pretrial motion and other practice that you need to do, and keep on a tight schedule. I've found the federal court is extremely accommodating in that regard. Get to know the clerk and their schedule, and really just work to accomplish that. Few just kind of practical things to be thinking of with these international matters. If you need translation services, make sure you get them, whether it's to have documents translated from their native language into English, or the reverse of that. Needless to say, if there are documents in a foreign language, appending them to a pleading in federal court here without a certified translation is not going to be helpful to you. And so make sure you do that. Also, if you are dealing with a client that doesn't speak English well, or has difficulty understanding English, make certain for your protection, and also to be able to best advocate for them, that you have translation services in place, so that you make sure you get all of the facts and information that you need, and so that everybody on these really critical, important matters is understanding one another. The good thing is, for cases on referral from the State Department, they have a translation line that helps immensely. It's almost always available. Utilize that, and certainly if you are in a trial setting and you need a translator, to be there, certainly do that. Be thinking, if you, prevail in a case, or you're likely to prevail, or you're just preparing to prevail, be thinking about a few different things, just logistics. When it might be appropriate for a child to transition back to a parent in another jurisdiction. When is school ending? Is there a sensible time that's least disruptive for a child to be able to return? I've found the federal court is extremely sensitive to that, and really focused on, in that case, what is in the child's best interest. Obviously extremely disruptive, regardless of blame, or who is right or wrong for a child to be in these situations, and often because of a parent engaging in self-help, but it's obviously not the child's fault. And I found the court and certainly practitioners alike want to do what's best for a child at this delicate stage. If a child has come here on a passport, check to make certain that their passport is valid, that they have proper travel docs, especially in COVID. Utilize the State Department, and even when there was a ban on travel, there are ways to get around that. If a child pursuant to a court order needs to be returned, familiarize yourself with any of the restrictions in place. For a minor child, great if you win a case. If the judge orders the child to be returned in 2 weeks, how is the child getting there? Presumably on a plane. If they are too young to fly on an accompanied minor program, or too nervous to do it, they might be of age to fly on a unaccompanied minor program, but that might not be something that the child feels comfortable with, and it may not be the best thing for that child. Can your client come here to pick up the child? Can a trusted adult come here to pick up and travel with the child? Be thinking, this sounds simple, but do not book a flight where there are 4 connections to get a child from here to Brazil, or whatever the case may be, where a child needs to, by themselves, potentially, even if they are of age and able to fly, on an unaccompanied minor program, where they need to get themselves on their own through an international airport. That's stressful and not optimal, obviously, for a child. And so be thinking about all of those things. Does there need to be language reimmersion? Does a child need to be re-enrolled or signed up for schooling or other types of things? Make sure, and again, this sounds, simple enough, and that it would be a given, but make sure your client is prepared for the return of this child. Is there a room still set up? Have they signed them up for school? Are the teachers and other, adults, and professionals that will be involved down there prepared to welcome this child back in, and just making certain that there is a support system in place. As far as, let me just see if there's anything else. I will mention this just to close up as far as practice tips and, just to be wary of. If you are representing a client or engaged in a divorce where a party may have international ties, whether it be a dual national, whether there be multiple passports, whether they have family ties in another jurisdiction, be cautious. If it is a low conflict divorce and everyone is used to traveling internationally and there are no issues, that is one thing. If the children are old enough, they have cell phones, they have their passports, and they're able to communicate when they're abroad, whatever the case may be. That's different than a 4 or 5 or 6-year-old child that may have a passport that may not be able to successfully advocate for themselves. So what do we do in circumstances where there could be a risk of flight? First of all, just have your eyes and ears open. If there are attempts to remove, or a party in the midst of litigation wants to travel for vacation, just be really cautious with that. If there's a real risk or concern, have passports held in escrow, have them held by the court. Take those steps so that you don't end up in a situation where a child is wrongfully removed or retained against another party's wishes and without consent. While obviously there are skilled practitioners and systems in place in order to secure the return of children that have been wrongfully removed or retained, that isn't always the result, even with a lot of effort. And so first priority is obviously not to allow yourself to get into a situation like that. Take affirmative steps to be able to protect that child and make certain, ideally, that we don't get stuck in a situation like that. And so with that said, we are about 2 or 3 minutes over. I want to be really respectful of everybody's time. I know one of the questions by one of our attendees was akin to what do we do in order to, and these are my words, not theirs, but what do we do when a child has been wrongfully removed or retained in order to secure their return, if somebody is really doing all they can to avoid that? And I would say this, obviously finding that child is critical, utilizing skilled professionals like private investigators is really helpful in order to find that child. But then don't engage in self-help. Don't be creative in the sense, I'm going to go over to that jurisdiction and I'm going to bring them back here on vacation. It will, ignite the ire of the judges that are potentially going to be deciding your dispute. And keep in mind, it might be that jurisdiction. And so you don't want to engage in self-help. You want to do it the right way. It can be really, really challenging to be patient with often gut-wrenching circumstances like this. But trust the law, trust the process, pursue your relief vigorously, and make certain, especially when you're dealing with someone that has engaged in self-help and done the wrong thing, 2 wrongs don't make a right. And so make sure you're not also in that situation. You really want to be coming to the court with clean hands, having done the right thing, and certainly trust the process in that regard. And Katie, anything else you can think of before we wrap up here?
I would say, just to follow up on that specifically, like you said, you don't want to muddy a good case by engaging in any type of self-help that the court could potentially hold against you in the future, whether it's during that specific litigation or future litigation. And so I would just say be cautious of the steps you take and make sure that they are appropriate. And the other thing I will say, just to follow up on what Elizabeth had mentioned in terms of situations where you can prevent certain things like this from happening, if you have concerns as a divorce practitioner or somebody getting a divorce about countries that your spouse may be traveling to with the children, you can certainly agree to certain restrictions about those, whether it be we are only going to travel with the children to countries that are signatories to the Hague Convention, or this is, we're agreeing that our international travel is going to be limited, or the passports to be held in escrow. So there are certain creative ways that you can try to preempt situations like this from happening.
Absolutely, and great advice. And we just want to thank everybody for joining us this afternoon. I hope it was helpful. I hope you found it interesting. And sincerely, if any of you have questions or we can be helpful in the future, don't hesitate to reach out. We've done a ton of these cases. I've done a ton over my career, and so oftentimes, if things come up, reach out, pick up the phone, shoot us an email. We're delighted to be helpful, and we enjoy this type of work. And so don't hesitate to reach out if we can ever be helpful or go over an issue with you. And wish everybody a wonderful afternoon. Enjoy the great weather. And if you have any questions or follow up, don't hesitate to reach out. It would be our pleasure to be helpful. Thank you so much. Take care.
Thank you. Thank you all.